Okay, is everyone here?
Good afternoon, Your Honor. Diana Faust here on behalf of the defendant.
Michael Fetchner on behalf of the plaintiff with Mike Lyons and Jeff Levenger.
Let me go ahead and call for announcements first. So, Tony, are you ready?
Yes, Judge.
Let's go on the record on cause number DC 20174990, Judy Adams versus Flower Mound Hospital Partners LLC et al. Counsel, make your appearances.
Michael Fetchner with Michael Lyons and Jeff Levenger for the plaintiffs.
Diana Faust and Michelle Robertson on behalf of the defendant, Your Honor.
Okay, and we're here on a motion for new trial, correct? And other motions?
Yes, Your Honor, the post-judgment motions filed by the defendants.
Okay. You may proceed.
Thank you, Your Honor. The defendant filed 3 post-judgment motions in this case. The first, and 2 of those I want to specifically address today, but 2 of them, the motion for new trial and the motion for J&OV, as the court is aware, are sort of what we call placeholder motions because we included in those motions challenges to the sufficiency of the evidence, which we're required to do for factual sufficiency in a motion for new trial. And then we also filed a motion to modify the judgment. Today, I wanted to focus on essentially 3 issues that impact the new trial motion and the motion to modify. So depending on the court's preference, I can begin with the motion for new trial, and then if the court would like the plaintiffs to respond, and then the court can rule on that motion, we can proceed to the motion to modify.
I have no preference.
Okay, thank you, Your Honor. With respect to the motion for new trial, I want to talk about 2 specific things. Even though we raised several issues in our motion that were preserved during trial, we wanted to point them out again in our motion for new trial, Your Honor. The court may recall in this case, the first has to do with the failure to allow the defendant to argue the reasonable inferences and deductions that arose from the evidence that came in unobjected to during trial, and that has to do with the evidence concerning the alleged delay in providing care to Mrs. Adams. The court may recall that the plaintiffs pre-admitted exhibits 15 and 16, which were the exhibits showing the timeline of the MRI queue and the timeline for the MRI of the patient ahead of Mrs. Adams. The evidence was that the emergency room doctor, Dr. Odedra, ordered the MRI at 17:04, and that Ms. Tucker, who was the technician for the hospital on this MRIs, reviewed the chart at 17:14 and started the MRIs at 18:31, and plaintiffs alleged an unreasonable, improper delay in starting the MRIs. Now, Ms. Tucker was called to testify and testified that during the time between the time the orders were given and the time that the MRI was started, they were also treating another patient. MRIs were undergoing for that other patient at the time. And
Now, wasn't there also evidence that she had checked out at that time period, or she had clocked out during that time period? Wasn't there, if I'm remembering the evidence correctly, there was evidence on the timesheet that she had actually clocked out during that time period, correct?
Your Honor, I'm not sure what the entire evidence showed, but that is what the plaintiff has indicated in their response to the motion for new trial. Yes.
I mean, so wouldn't that be a fact issue for the jury to make a determination if they believed her that she had another client, or if she had actually clocked out? It was up to them to make that determination. Isn't that at least a fact issue?
It could be, yes, Your Honor, absolutely. But the error that we're complaining about here, respectfully, Your Honor, is that the court didn't allow us to talk about exhibits 15 and 16 because exhibit 60, which were the plaintiff's interrogatory answers, purported to establish a different timeline, and the court determined that that timeline governed what happened here, and that we couldn't go beyond that in trying to argue something different. Now, Exhibit 16 specifically was used by the defendants during trial repeatedly without objection from the plaintiffs. And the other testimony that came in with from Ms. Tucker was without objection in using Exhibit 16. Now, the law is clear that when evidence comes in without objection, it's in for all purposes, and it's a proper subject to closing argument. And the attorneys may argue the reasonable deductions and inferences from the facts in closing argument. And that's the Reuter versus Jordan case out of Dallas and the In Re Toyota motor sales case out of the Texas Supreme Court. And we believe respectfully, Your Honor, that it was error to not allow us to argue about this because it is a fact issue as to whether or not there was a delay and whether the conduct was appropriate. But we think that this error was harmful because all of that evidence went to a crucial issue in the case. Was there delay in treating Mrs. Adams? And because we were not allowed to argue that, we believe it was a harmful error. Now, the plaintiffs filed a response late Friday, and in the response, they argued that the plaintiffs did not make an offer. I mean, the defendant did not make an offer of proof regarding what the argument would be, but offers of proof go to admission or exclusion of evidence, specifically exclusion of evidence, not argument during closing arguments. So there was no need for the defendant to make an offer of proof regarding what the argument could be. So that's the first issue, Your Honor. And then the second issue goes to the jury's award of future medical expenses of $3 million. The court will recall that the parties had stipulated during trial that the number that the jury assessed for future medical expenses needed to be adjusted post-verdict. It would be adjusted based on agreement of the parties, or it would be adjusted if the parties could not agree by a finding from this court. Now, the post-verdict, there was a report sent to the defendant by the plaintiff from Dr. Naiswatamy. The defendant felt the report was conclusory, could not just agree to it. So this court heard Dr. Naiswatamy's testimony on the morning of the hearing on the motion for judgment. And after that hearing, or during that hearing, the court made no finding on what the future value was. Dr. Naiswatamy testified it was $2,828,696. The court then, during the hearing on the motion for judgment, took the parties' arguments, and with respect to this particular issue, the defendant preserved it in its objection to the proposed motion for judgment that had been submitted to the court prior to the hearing. Now, following the hearing, another proposed final judgment was submitted to the court, and that is the version the court signed on March 6th. That was submitted to the court, however, without first providing it to the defendant. Nonetheless, at no place within that final judgment does it state that the court accepted Dr. Naiswatamy's number of $2,828,696. There are no computations contained in that judgment concerning what sum of credits would be, what prejudgment interest would be, or anything that would involve the future medical expenses number, that the $3 million that the jury assessed. So if the court did actually agree with Dr. Naiswatamy's number, we need to know that. And the final judgment does not indicate that. If the court does not agree with Dr. Naiswatamy's number, then we should have a new trial for the jury to actually tell us what it is. And so we would ask the court to tell us what the court concluded. And with respect, if the court does agree with Dr. Naiswatamy and did agree with Dr. Naiswatamy by signing the final judgment, then we still believe that the final judgment should be modified in several respects that I can address later.
All right, response?
Yes, Your Honor. So I'll address these in the same order. As the court mentioned, much of Terry Tucker's conduct was a fact issue for the jury to determine. The specific issue that's raised here is that defense counsel tried to make an argument that a nondescript number on a certain exhibit meant that an MRI was being conducted at a certain time, when there was no evidence to establish that that's actually what that number meant or what that time meant. In fact, defense counsel's argument contradicted the sworn interrogatory testimony and the corporate rep testimony establishing when certain MRIs did and didn't occur. And so my understanding, and I don't have a record, and the defendant has not submitted a record of what the court actually ruled. I'm not sure if the court actually rendered a final ruling on whether they could or couldn't make any sort of argument. So I don't know that they have preserved that issue, but besides that, the only issue here.
Ms. Spouse, do you have a copy of my ruling, or did I make a written ruling?
No, Your Honor, we do not have the record yet. We've not requested the complete trial record yet. We typically do not do that until we have rulings on our post-verdict motions.
And further to that point, there is no record before the court that the court's actually made any ruling that could be adverse to defendant here. The bigger issue, though, is that if the court did make such an order, all that the court did is it stopped defense counsel from making a leap in judgment that a certain number meant something that there was no other evidence to establish that that's what the number meant. And so the court did hear arguments from counsel, and plaintiffs did file a motion to exclude any argument from defense counsel related to this issue, to which defendant never responded. So I think the court was well within its discretion to exclude any argument, if it even did that. So we asked that the court deny.
I can just jump in because I do remember this, Judge. You never ruled. In fact, as the jury was being brought in for closing arguments, Mr. Schell asked for a clarification of what the boundaries were, and he never got a ruling on that. And I mean, I certainly asked. I thought what they did was a violation of the discovery rules to try to contradict their own interrogatories that we relied on. But nevertheless, there was never a ruling. So I'm not sure what the basis of this is. I don't know how it could ever be construed as harmful based on what Mr. Fetchner said, but that's what my recollection is, Your Honor.
I don't have a specific, I mean, I remember the argument being made. I remember Mr. Lyons was quite passionate about that issue, but I don't honestly recall what I said or what the ruling was. I definitely didn't make a written ruling, and there definitely was nothing to, there's no offer of proof that I can recall. So if Ms. Faust, you get the record in and it turns out I did make a ruling, I'd be glad to look at it again. And then, I'm sorry, we interrupted you, Mr. Gresham. Was there anything else?
The second issue is the net present value that Ms. Faust mentioned. Dr. Neswadomi did appear and give testimony in a report the morning of the hearing on the motion for entry of judgment. Dr. Neswadomi said that the net present value of the $3 million award was $2.82 million. And the court, in its final judgment, the number that the court entered judgment on necessarily incorporates Dr. Neswadomi's net present value calculation. So while there may not be a specific finding, there is an implied finding by the court's judgment that the court did accept Dr. Neswadomi's $2.82 million calculation. In fact, there was no other calculation offered by plaintiff or defendant in that regard. And so we'd ask that the motion for new trial be denied.
Motion for new trial is denied without prejudice to Ms. Faust bringing up that argument if she gets the record.
Thank you, Your Honor. With respect to the motion to modify the judgment, Your Honor, we think there are two areas the court should look at. The first is the computation of the settlement credit, and the second is the periodic payments order. With respect to the settlement credit, Your Honor, we believe that if you take the $2,828,696 based on net present value of the future medical expenses, then and apply that to the computations required for computing a settlement credit. We believe that the judgment is high. It's too high because, and we think the discrepancy lies in the computation of prejudgment interest. The plaintiffs compute prejudgment interest, and they make this clear in the response they filed late Friday. They compute prejudgment interest on the entire amount of past damages rather than past economic damages and capped past non-economic damages. Now, the Texas Finance Code is clear under section 304.104 that prejudgment interest accrues on damages awarded in the judgment, and non-economic damages awarded in the judgment are only capped damages, not the full amount of past damages that the plaintiff used to compute prejudgment interest. So we believe that based on that adjustment, I'm just doing some quick math, I think the prejudgment interest would have been more in the realm of about $136,300, something of that nature, rather than the $381,000 that the plaintiffs computed the settlement on. Now, the settlement credit itself is first applied to the prejudgment interest, then anything left on the settlement credit would be applied to past damages. Leaving anything left on the settlement credit after that would then be applied to future damages. We believe that after applying the settlement credit to prejudgment interest and past damages, we have about $840,000 of the settlement credit to apply to future damages. And so after applying credits and remaining future damages and the cap, because they're entitled to the 250 cap, the judgment should be more in the area of about 3.4 million. That is 3.399,669 more or less, rather than the 3,476,258 that the judgment awards. And again, the discrepancy is because they've used the full amount of past non-economic damages found by the trier of fact to compute prejudgment interest. Once that would be computed on the amount of the cap only and the portion of past damages included in that, it brings that down, brings that prejudgment interest number down significantly by over $200,000, we believe. So we think that's where the error lies in the judgment computation, and the court should take a look at that. Now, with respect to periodic payments, there are a couple of issues. First of all, the time period. Well, let me just back up. First of all, with respect to Mr. Adams, respectfully, the court awarded nothing in periodic payments to be paid for future damages to that were awarded to Mr. Adams for loss of household services and loss of earnings. When the evidence in the case was that Mr. Adams was going to lose those and incur those damages and lose those earnings because he was taking care of Mrs. Adams. And Mrs. Adams' life expectancy was 10 years. So the future damages of about $700,000 awarded to Mr. Adams, we believe. The record supports the court in its discretion awarding some part of that at least over the period of time of Mrs. Adams' life expectancy, because the evidence that the jury heard and considered in awarding those damages was that he was going to lose it because he's taking care of her. And we know what that time period would be according to the other evidence in the case. Now, with respect to Mrs. Adams, the period of time that the court did make an order for some periodic payments in the case, as the plaintiff in the computation and the amounts that the plaintiff suggested, and that they were to be paid out. In fact, the judgment says they must be paid quarterly over a period of 2.25 years, rather than over the period of Miss Adams' life expectancy, which is 10 years. We believe this conflicts with the evidence that the jury heard in coming to the future damages number that it did. And because it conflicts with this evidence, we believe that it constitutes an abuse of discretion under the way that the statute works, Your Honor. And frankly, there aren't a lot of cases yet out, but we think that there is one case that that we can learn from. And that is the Columbia versus AMA case out of the Texas Supreme Court in 2022. And in that case, the court made clear that the court does have an abundance of discretion in determining how to award periodic payments for future damages in accordance with the statute, but it cannot deviate from the record. And the record here is that Ms. Adams has a 10-year life expectancy. She's going to get payments for the first 2.25 years. Are we just to assume that money will be there after that to take care of her needs? That's the whole purpose of the periodic payment statute, Your Honor. And so we believe that the amount should be ordered. There was no evidence of immediate care needs, although the court can consider that in determining lump sum. The court also should consider what she would owe on those future payments in attorney's fees. And can, within its discretion, say, I'm going to say, assume a third or 40%, whatever the court believes, and say that that amount should be paid in lump sum because the statute does not address that attorney's fees are to be paid periodically. We think that the period of time needs to be adjusted and modified in a final judgment.
So,
And even if-
Mr. Mr. Levenger, so I want to go back to the original argument here about, is there a calculation provided of how you got to the prejudgment interest? Did you calculate it based on the total judgment or the judgment after the cap was provided?
Your Honor, yes, there is a calculation, and it was set forth in one of our amended motions for entry of judgment. We've also set it forth again in our response to the motion to modify. We go through the whole math again.
Okay.
And the prejudgment interest was calculated only on the past damages, not the entire award by the jury.
The past damages capped or the total past damages?
I think that Michael will correct me if I'm wrong, but I think it was calculated on the past damage, not capped.
Correct. And that's based on the Regent Care of San Antonio case that provided the framework by which the court should, the steps by which the court should do the calculations, which is that you calculate prejudgment interest, then you apply the settlement credit, then the damage caps are applied, not the other way around.
If I may respond, Your Honors, Regent Care, that is what Regent Care says, but it did not say that you compute prejudgment interest on the total amount of past damages found by the jury. That was not an issue in Regent Care. And the finance code, not Chapter 74, governs accrual of prejudgment interest in a medical malpractice case. And it says that prejudgment interest accrues on the damages, the past damages awarded in the judgment. And we know that will only be the percentage of the cap that constitutes past damages. And so we think that the final judgment awards more than it should because of the error in the computation of prejudgment interest. I also have one more issue with respect to.
I want to hear Mr. Levenger respond to the next issue.
Okay.
Well, I'm not sure that's correct because when you start applying the settlement credits, the prejudgment interest, both the way we calculated it and the way they calculated it, are wiped out. They become zero. Then you apply the settlement credit next to past damages, and that wipes them out. And then you start applying the settlement credit, what's left of it, to future damages. And my notes from the last hearing we had on this show that at this point we were pretty much aligned. Both sides are pretty much aligned in terms of what that number was. So it all kind of falls out as you start, applying the settlement credit and wiping out prejudgment interest and then past damages.
Well, let me ask kind of the big picture here, which is, that Dallas Court of Appeals has it used to be, I used to hear defense attorneys say all the time that, yeah, you may get a big verdict, but the Dallas Court of Appeals is just going to take it away. I'm sure Ms. Faust hasn't said that, but I've definitely heard other defense attorneys say that. I don't hear that as often anymore from defense attorneys. And so I guess my question is, is there anything on appeal, Mr. Levenger, with the way the judgment is currently written that's going to subject us to reversal or modification?
I don't think so, Judge. I looked at the calculation the first time around when we did this in I believe it was early March, and it looked right. And then I looked at it again as Mr. Fechner prepared the response to the motion to modify, and it looked right again. So I don't think so.
I guess the other issue I would have is just there always is a risk on appeal. I think somewhat less risk now with the Dallas Court of Appeals than it used to be, but there always is risk. It could go to the Supreme Court, or the Dallas Court of Appeals could see something here that I've missed. So I'm inclined in larger judgments like this to send the parties to mediation prior to, while I still have plenary power. Does anyone strongly object to that?
Your Honor, I would check with our trial team and our client. I know of no objection at this time. I don't know what the past history has been on the settlement negotiations. Of course, I haven't been involved.
Yeah, Judge, I don't know if you want to hear from me on this. I can tell you what this past history is that they've jacked around. They've never been serious about resolving this case. And that's what forced us to get a near $11 million verdict. So I don't know if they've sobered up now, but I could tell you that this would be the third. Is it the third or fourth mediation, Michael?
Would be the third.
Yeah, we'll obviously do whatever the court wants to do. And
Who have you mediated with so far?
we've mediated with Judge Ashworth, who told them this is a case they need to settle, which they ignored. And then we mediated with Michael. Who do we mediate with during trial?
Michael Pennick.
Michael Pennick, who also told them need to resolve this case. And they ignored him also. So I don't know.
Your Honor, if I might respond, the fact that the parties can't agree on a number doesn't mean that they're ignoring anything. And I respectfully object to these allegations that we're ignoring things. You know, we couldn't agree on the number for Dr. Naiswatamy, and I'm sorry if I'm mispronouncing his name. That doesn't mean we're ignoring that the evidence is there. Also, Your Honor, with respect to, there's another issue in the final judgment that's very important. And that is that the final judgment does not address the requirements of section 74-506B and D. Now, 506B says if the plaintiff dies before all of the periodic payments are to be made, then the remaining periodic payments that have been ordered there's no more obligation. They cease, they terminate. And 74.506D says in the if any type of security has been placed for those, such here would be in the form of either a supersedious or some other type of security, if it's still remaining at the time the obligations terminate or they are satisfied, then they revert back to the defendant. And the Columbia versus AA case out of the Texas Supreme Court reversed in part on this very issue because the judgment did not address the requirements of the statute to provide that upon termination of the obligations, that any security would revert back to the defendant. And it needs to be in the order. And the final judgment that was prepared, it does, Your Honor, and the statute is very clear on that. Otherwise, we have no, other than the statute itself, the court would be able to come back and modify a judgment if it granted periodic payments with respect to loss of earning capacity. But the obligation terminates with respect to the future medical expenses if Ms. Adams would, God forbid, die during the 2.25 years the trial court has ordered these payments to be made. Anything after that time would cease and terminate. And that should be in the judgment so that the the requirements of the statute are met. And for that reason, the final judgment needs to be modified.
Does the statute require it to be in the judgments, or does the statute just require it to happen?
The statute requires
It just requires that it happens.
I mean, I don't have a strong opinion either way there. If you guys want to modify the judgment to indicate that, you can. If you don't think it's necessary, I don't have a strong opinion.
but we believe it's necessary, but we would ask the court to do that. And those are the two arguments that I'd like to focus on today with respect to modification of the judgment. The prejudgment interest, the finance code is clear. You compute it on the amount awarded in the judgment, not the full amount of past damages, which they've admitted that they computed it on. It makes a difference here. It's 250,000 versus several million.
The issue on the prejudgment interest is that the Texas Supreme Court took this issue up in 2020 in the city of San Antonio, the Regions case.
Yeah.
And it provided the order of calculation, because if you do it how the defendants want to do it, you're triple discounting. You're basically giving them a double effect of the non-economic damages cap, which that's not the intent. You're letting them double count that. So the Texas Supreme Court provided that you apply the damages cap, the non-economic damages cap, only after you do the other calculations, including the prejudgment interest and the settlement credit.
But that's in determining what the judgment amount is. And we are not going against that. We completely agree with that. The court never took up the issue of how to compute prejudgment interest respectfully. That is not an issue in the case. The issue was, do you apply the cap before credit or after the credit? And the court said before the credit.
Court said after the credit.
Well, but you don't apply the cap. Correct. My mistake. It applies after the credit. So the credit comes off first and then the cap. That's exactly what we've done here. But to determine what prejudgment interest is on past non-economic damages, you have to only add the portion of past non-economic damages from the 250,000 cap. Otherwise you are in conflict with the Texas Finance Code.
Well, the Texas Supreme Court provided the order of calculation, and it said that the cap is only applied after the settlement credit is applied, which is after prejudgment interest is applied.
The prejudgment interest is only computed on the cap, the capped amount of past. The past damage is included in the cap.
The Texas Supreme Court disagreed, but
what didn't consider that?
That's the difference there.
Sir. Thank you, Your Honor.
All right, well, great, guys. I'm going to deny defendant's motions, and I mean, if you guys feel like this is, I guess my thought is, just based on my past experience, is that you had trial counsel that I guess has now been removed from the case for the defendants. Is that correct?
We will be leading the appeal, Your Honor, but they're still involved. Yes, I believe Mr. Campbell is on paternity leave at this time. Congratulations are in order.
Thanks. I'm here. My camera is just not working, but I've been here.
I'm sorry.
That's okay.
I mean, if y'all feel that it would be helpful to go to mediation, and I kind of think these types of cases, now that you have a judgment in place, I think it'd be a good idea to go. But if everyone says no, it's ridiculous and doesn't want to do it, I'm not going to force you. So if anybody, I guess I'll just say, if anyone thinks it might be helpful, I'd be glad to send it. So Ms. Faust, do you think it might be helpful?
You know, I'm always in favor of mediation, but I defer to everyone who's been in the case longer. I believe the Dallas Court of Appeals will also ask us about that. You know, and before the expenses are incurred for briefing, it might be a good idea. I don't know, but we
What do you
haven't seen
think?
the record, which is another consideration.
Mr. Levenger, what do you think? Are they going to order you to mediation at the Court of Appeals too, do you think, or?
You know, that they used to do that quite often, but they've done it a lot less now. I think Ms. Faust can attest to that as well. You know, they'll fill out the docketing statement. They'll probably check the box that the case, you know, could be potentially mediated, and then the Court of Appeals will do what it wants with it. But more often than not these days, it is not ordering mediation. I've had them order mediation actually after they hear oral argument, but it's kind of late at that point. I mean, it's not to say it wouldn't settle, and the case I had, it did settle. But by that time, we'd spent the money on the briefing and oral argument, so it kind of defeated the purpose.
All right, I'm going to go ahead and order it to mediation. Do y'all have any preference on who I send it to?
Well, Glenn Ashworth already knows the case.
Mr. Campbell, what do you think, Ms. Faust?
Yeah, we weren't involved in the case yet. Whenever that was mediated with Glenn Ashworth, I'll have to ask my client if that's who they would prefer as well. So I don't think it is based on just kind of past experience, but I'll double check with them.
Was there somebody else that you guys would like to use?
Not anyone I can think of off the top of my head. Besides, I mean, you know, we mediate the majority of these med mal cases with Dan Marley, and he's the only one I know that we haven't had on this case yet.
Yeah, Ms. Faust, who do you like to use?
Well, I think Dan is certainly good. I think any of these would be good in the case, Your Honor. I would recommend either of them.
I think, Judge, we'll do whatever you want us to do. My experience with Dan Marley, who's a former MedPro adjuster, which is MedPro is the carrier here, is that I've not had any success. In fact, I think the last time I said I'll never mediate with him if given a choice. You know, here's outside the box thinking. You were considering Joel Steed during trial, and there was a conflict because a partner of Mr. Steed's office was representing this radiologist that they tried to call. Do you remember that?
Yes.
Well, obviously the case has been tried. We would waive that conflict for purposes of mediation, but I think Joel Steed would be good. I think everybody respects Joel.
Agree.
I think Joel would be perfect for this.
Assuming he has availability.
Right.
All right, Rhonda, let's go ahead and order this back to mediation with Joel Steed. I think that's an excellent idea, Mr. Lyons. And hopefully he can get it done.
Do you have a particular date?
When is my plenary power expire?
Michael, do the math.
I'm trying to do it really quick.
I did too much math putting together the judgment. I mathed out for the year.
Assuming you're signing you're signing the order denying the motions today, then somebody quickly look at a calendar.
30
It'd be
30 days.
30 days.
May
if you
30th.
sign those today.
Right.
All right, I'm going to order the mediation to occur within the next 30 days.
Okay.
All right.
Your
Guy?
Honor, do you anticipate signing the orders? They were the proposed orders that were filed denying?
Yes.
I mean, okay, thank you.
All right. Well, good luck with everything, guys. I hope it works out. Mr. Steves, I've heard is an excellent mediator. I never mediated with him myself because he's pretty new to this, but I've heard great things. And so good luck with that. And you guys have a great rest of the week. Okay.
Thank you, Your
Thank you,
Honor.
Your Honor.
Thank you, counsel.
Thank you, guys. You have a great rest of the day.
You too, Judge.
Or we have one more hearing. Okay. Are both sides here on the Wilder case?
Yeah, hey Judge, Josh Hancock here, appearing on behalf of James Bogus for plaintiff Xavier Wilder.
And John Roddy Pace here for defendant Paralysis.
All right, Tony, let's go on the record on DC 228641 Wilder versus Pross. Council, make your appearances.
Joshua Hancock here for plaintiff Xavier Wilder.
And John Roddy Pace here for defendant Benigno Paralysis.
All right, so this is just the motion for leave to allow them to file a controverting affidavit. Is that correct, Mr. Hancock?
Yes, I believe defense counsel set this hearing. Jim filed a response to it. I think it's pretty straightforward, Judge, but I'm happy to argue it on his behalf if you'd like.
That's fine. I mean, it was 8 days late, right?
Correct.
You know, I'm not a huge fan of counter affidavits usually because they're a lot of times just delay trials, and I don't think they're necessary sometimes, but you know, I mean, it's 8 days. It wasn't, when is our trial setting? Is this going to bump our trial setting?
It's currently set for August 15th of this year, Your Honor.
All right, I'm going to allow him to file counter affidavits, but you got to get them on file within the next week.
And Your Honor, we've actually already served those counter affidavits in conjunction with our motion. At the time we filed the motion, we did not have a trial setting. And so, I mean, at this point, they've been served. They're in the record. We're ready to, proceed with it. I do believe we've got the plaintiff's deposition set and still a little bit of discovery to do prior to our trial setting, but it at this point, it's not going to slow anything down at all.
All right, I'll go ahead and sign the motion, and then I guess if you guys can't get this case settled, you can file your motion to strike it if you decide to do that.
Understood.
All righty. Anything else today, guys?
Nothing else, Your Honor. I appreciate your time.
All right. You have a great day.